We are coming to you from our studios in Kansas City and St. Louis. Studios is a more professional way of describing converted conference rooms with new chairs and plastic plants, so hope you enjoy it. A few housekeeping matters before we get started with the formal program. First, there are multiple application icons down at the bottom of your screen. One is a question box. If you have questions throughout the presentations, we invite you to type those in. They won't be answered in real time by the presenters. The presenters won't get them, but we've got folks standing by to read the questions. They'll either be answered in real time by other folks, other of our attorneys, or else the presenters will go to a green room afterwards and answer. Or in a rare case, if you've sent us a real stumper, we might follow up with you a little later, but we will respond to all questions, so feel free to use that if you have some. There's also at the bottom, you'll see a resources folder. That'll give you access to the PowerPoints, as well as other resource materials following the presentations. It's approved for HR and continuing legal education credit. You'll see a CEU box down at the bottom. You can click on that. We'll send you a certificate of attendance. You'll also get verification that you've attended for your records. We have poll questions today. I think we have 3 or 4 throughout the presentations where you'll be asked a question and you'll have an opportunity to give your input. A couple reasons for that. One, it's necessary for the HR and the continuing education credits, but maybe more importantly, it's a little bit of new technology for us, and we're kind of having fun with it. So bear with us, and we'll have fun with that as well. I think that's it for all of the housekeeping. Today we've got about 2 hours of content. We'll keep it to that so we don't take you beyond your lunch hour. There are 6 sections of substantive content. 3 are a little longer, maybe about a half an hour, and 3 are shorter, more rapid fire type topics. We don't actually have a formal break built in, so feel free to step away as you may need to throughout the presentation. First off, to kick us off, we've got, since before the pandemic, there were problems and issues with mental health issues and how to avoid those and treat them under the ADA. But even more so now, they've been increasingly relevant to HR professionals and legal professionals. So here to talk through some of those issues with us are 3 of my partners from Kansas City, Julianne Story, Tyler Hibbler, and Tim Hilton. All 3 are seasoned litigators and also quite experienced HR and labor law consultants. So Julianne, Tyler, and Tim, I send it over to you.
Thank you, Paul, and thank you all for joining us. Mental health in the workplace is a subject that is top of mind for everyone these days, regardless of your role as an employee, as a supervisor, as a human resource professional, as in-house counsel. We have a robust agenda today. We're going to cover some statistics about mental health and the ADA. We're going to talk about the basics of mental health claims under the ADA. And then we'll cover some common challenges, identifying a mental health disability, determining accommodation, and dealing with disruptive behavior at work. We're also going to talk about the FMLA rules as applied to mental health conditions, and we'll wrap up with a reminder on some mental health resources that employers are using to support their employees. Tyler?
Thanks, Julianne. So when we're talking about mental health, let's start with square one. What are we discussing? When we're referencing mental health conditions or disabilities, we're discussing a wide range of disorders that constitute all sorts of things which may affect an individual's mood, thinking, or behavior. This includes conditions like depression, post-traumatic stress disorder, bipolar disorder, obsessive-compulsive disorder, and even anxiety. And why is this important to employers? Well, as identified on this slide, The prevalence of mental health conditions within the United States is not only vast, but it's growing. According to statistical evidence, nearly 20% of U.S. adults currently suffer from some sort of mental health condition. Of those individuals, 5% of the individuals in the U.S. adult population are currently experiencing a serious mental health illness. And this isn't just limited to the adult population. Approximately 17% of individuals aged 6 to 17 are currently facing or dealing with some sort of mental health condition. So this is prevalent throughout the workforce. And with prevalence in the workforce, obviously comes additional challenges for employers. This includes increased risk, increased need for accommodation, and also increased risk to litigation and other sorts of exposure. This is reflected within charge data from the EEOC. In 2021, 37% of EEOC charges included a disability claim. Of those, approximately 1/3 included a claim of disability based on a mental health condition. Now, that is nearly a 50% increase in the last decade from 2011 to 2021. Notable subcategories where we've seen increases are claims related to anxiety disorder and claims associated with post-traumatic stress disorder. So why is this? Why are employers now experiencing more mental health accommodation requests and dealing with more employees who are experiencing mental health conditions in the workplace than really ever before? It's a combination of multiple factors. One, there's a lack of mental health resources currently right now in the country. Either individuals are strapped for cash and lack the funds or insurance coverage to receive appropriate treatment, or treatment simply not provided. Upwards of 119 million Americans live in mental health shortage areas where there's roughly one mental health provider per 350 individuals. Around 23% of adults experiencing frequent mental health distress report an inability to afford treatment options. This has been exacerbated since COVID. Individuals have experienced anxiety and stress related to potential direct health risks related to COVID-19, such as infection or potentially infecting loved ones. Isolation through quarantine and social restrictions has led to increased mental health conditions in the population. And finally, economic and professional uncertainty, whether it's through fears of a recession or simply being interrupted professionally and isolated from coworkers. All these things have kind of created a perfect storm, so to speak, for an increase in mental health conditions within the workplace.
Thank you, Tyler. So we have a poll question here today, and the question is, how many of you have seen an increase in the number of requests for accommodations for mental health conditions since March of 2020? So we'll give you a few seconds to work on that. Obviously, there's a relevant starting point there with the onset of the pandemic, and in addition to all those factors that Tyler noted a moment ago, it does seem like just in the general public discourse that there's a bigger understanding, a bigger public consciousness of mental health, even just in the past few years. As Tyler said, there's approximately 1 in 5, approximately 20% of Americans dealing with a mental health condition. After declining for a few years, the suicide rate went up in 2021. So those are, as Julianne said, things that are top of mind for everyone. And here in the results, and those are borne out in the results. Over 55% of you, so a clear majority, say that you have seen an increase in the number of requests for accommodations for mental health conditions just in the past approximately 2.5 years since the onset of the pandemic. So we're going to talk a little bit about the ADA basics, non-discrimination, and reasonable accommodations. I'm sure a lot of you are familiar with the basics, but it's always good to have a refresher. A disability under the ADA and typically under its state and local comparator laws is a physical or mental impairment that substantially limits one or more major life activities. Now, some of you may be familiar with when we talk about the ADA, we're actually talking about the ADA Amendments Act that was passed in 2008, which significantly expanded coverage. Congress looked at a number of the rulings that the Supreme Court had made on the ADA, namely the Toyota case, and found that it was applying an inappropriately high standard for what constitutes a disability. So when we say a major life activity, a physical or mental condition that limits a major life activity, that includes a major bodily function. Disability is also having a record or a history of such an impairment or being regarded as having such an impairment. So as relevant to the issue of mental health, major life activities include concentrating, thinking, communicating, working, and a major bodily function includes the neurological system. So all that sort of adds up to that it's very difficult to come up with a physical or mental impairment, a condition that does not impact one of our life activities or one of our bodily functions. And EEOC guidance has given some semi-per se coverage to certain mental health conditions, namely major depressive disorder, PTSD, bipolar disorder, OCD, schizophrenia, and certain personality disorders. EEOC guidance says that those are conditions that, quote, should easily qualify, and many others will qualify as well. But like any disability, it's not enough to simply have the condition that impacts your life activities or your bodily functions. To be covered, an individual must be qualified for the job, meaning able to perform the essential functions of the job with or without a reasonable accommodation. As an example, a client recently came to me to inquire about an individual that was dealing with grief and was snapping at their coworkers and being fairly aggressive and rude to some of their coworkers. And the question posed to me is whether this person would be covered due to their emotional distress. And the basic answer to that is that, one, obviously that's something that we want to be very sensitive to, but simply experiencing emotions, experiencing emotional distress in a colloquial sense is not necessarily going to be a covered disability. And that puts aside the question of whether we can give a reasonable accommodation for dealing with your coworkers in that way. So this sort of covers the basics of the non-discrimination part of the ADA, the things that you're not allowed to do. We all understand that you can't take employment action against someone based upon having a disability, having a record of disability, or regarding someone as having a disability. But the ADA and its state and local similar laws are somewhat unique in the employment space in that they also place positive obligations on employers beyond simply the negative obligations of not discriminating. And that comes in the space of reasonable accommodations. In addition to not discriminating, employers have to take reasonable accommodations for individuals with disabilities. In order to qualify, an accommodation has to be reasonable. It cannot pose an undue hardship or create a direct threat to workplace safety. And ultimately, it has to enable the individual to perform the job. EEOC guidance about mental health specifically has said that there can be some certain accommodations that may qualify, such as altered break or work schedules, quiet office spaces or devices that create a quiet environment, or changes in supervisory methods, such as getting written instructions from a supervisor who doesn't normally provide them, specific shift assignments, or permission to work from home. On the undue hardship and the direct threat, those are standards that EEOC is going to look somewhat strictly at. An undue hardship, EEOC is going to consider the cost, the impact on the work environment, and the employer's resources. So what may be an undue hardship for one employer may not be an undue hardship for a much larger multinational corporation, for example. And direct threat is an issue that we don't litigate or we don't deal with as much, but that's going to be looked at fairly strictly by EEOC as well, and it has to be something that's going to pose a significant risk of substantial harm to the employee or to others in the workspace. So basically, if you're thinking about undue hardship, if you're thinking about direct threat, understand that those are things that are going to be looked at pretty strictly by EEOC.
So let's look at some real-world examples of how employers can identify when a mental health condition rises to the level of a disability under the ADA. For example, depression alone may or may not constitute a disability under the ADA. As Tim mentioned, what is the critical factual analysis that takes place here is whether or not that impairment substantially limits one or more major life activities. Now, this is a fact-dependent analysis that's going to vary based upon case by case and individual by individual. The symptoms alone of a condition, for example, symptoms of depression, may qualify as a disability. These symptoms could include things like anxiety, panic attacks, migraines, or stomach problems. A real-world example of this is the case of Husch versus Delta Medical Cannabis Company. This was out of the Eastern District of Arkansas in this year, 2022. In Husch was a security guard. She was assigned typical duties as a security guard, patrolling, making sure doors were locked, making sure the facilities was secured. She was assigned additional duties on top of those tasks, which involved clerical work and more administrative tasks. Husch told her employer that these additional tasks were causing her a great deal of stress, causing her to experience depression. She was having anxiety and panic attacks as a result of these increased job duties and requested accommodation through a restriction of those tasks. Ultimately, the court, through a motion to dismiss, found that yes, these are valid potential disabilities that an employer must analyze in order to determine whether or not an appropriate or reasonable accommodation exists. Additionally, intermittent and situational mental health conditions can constitute a disability. For example, in Ramirez versus the Oklahoma Board of Regents for the Regional University System of Oklahoma, which was a 2021 case, Ramirez experienced situational anxiety, which she attributed to a hostile work environment. In other words, her anxiety would come and go based upon hostilities that she was experiencing in the workplace, and she requested accommodation related to that. The court recognized that these situational circumstances and situational anxiety and conditions can constitute a disability under the law. So that too is something that employers need to be aware of when an individual comes to them and identifies a potential condition that could necessitate an accommodation. Julianne?
Thanks, Tyler. As Tim suggested, almost everything is on the table in terms of an accommodation. In the post-pandemic workplace, especially in the context of mental health conditions, we are seeing requests for accommodation that go far beyond adjustments to the workspace. Employees are seeking reassignment, work from home, flexible schedules, and new supervisors. Let's take a look at a few examples of requests for accommodation and how the courts dealt with them. In the first case there on the screen, the Herman case, the plaintiff was a court clerk working for the city of Salt Lake. She had post-traumatic stress disorder resulting from a decades-long abusive marriage, and her symptoms manifested during hearings on domestic violence. Attending court hearings, of course, was an essential function of her job. She took FMLA for flare-ups, but after exhausting her FMLA leave and numerous conversations with her supervisor and HR regarding possible accommodations, she brought in a note from her doctor stating that the doctor recommended the plaintiff be given the opportunity to work in a different department with different supervisors. Her employer determined that because there was no accommodation that would enable her to do her current job, she was not qualified within the meaning of the ADA, and her employment was terminated. The trial court granted summary judgment for the employer, but the 10th Circuit Court of Appeals disagreed, finding that the employee's request for reassignment to a different position was plausibly reasonable, and that once the plaintiff made the request for reassignment as an accommodation, the burden shifted to the employer to engage in a good faith interactive dialogue to see whether reassignment would be a reasonable accommodation. Kind of a surprising outcome in that case. In the next cases, the courts took different views. In the Lamb case, the plaintiff was a litigation supervisor working in a law firm, and her job required her to work on a full-time basis and, when needed, work on weekends and evenings. At some point during her employment, she was diagnosed with generalized anxiety disorder and panic attacks. In response to criticism regarding her sporadic attendance, the employee brought in a note from her counselor stating that she should only work half days when she experienced intense anxiety. The employer in this case, importantly, had a written job description that included the essential functions of full-time 40 hours of work per week, personal meetings with attorneys and other staff, and in-office meetings with clients to perform certain specified tasks. Her employer, upon getting the counselor's note, concluded that the requested accommodation was unreasonable and terminated the plaintiff's employment. And the court agreed, stating that deference should be given to an employer's description of the job and its essential functions, and that the requested accommodation was not reasonable because it would not have allowed the plaintiff to do the essential functions of her job. In this case, the court also found that the parties had engaged in an interactive dialogue, and that dialogue had not resulted in identifying any additional alternative accommodations. Similarly, in the last case listed, the Brown case, the plaintiff had post-traumatic stress disorder and anxiety resulting from his military service, and he told his supervisor that his conditions affected his ability to manage stress, concentrate, and communicate. In this case, the plaintiff was a member of a 4-person team responsible for investigating fraudulent healthcare claims, so his job necessarily required him to work during regular business hours and to have in-person, in-office interactions. He sought accommodations of more work-from-home days and the ability to work on weekends to make up for his lost time in the office during the week. The employer denied these 2 requested accommodations, but the employer did agree to minimize his travel and provided him with noise-canceling headphones to wear when he was in the office to minimize distractions. The plaintiff quit his job, alleging constructive discharge and failure to accommodate. When considering his claims, the court rejected them, finding that his telework and weekend work requests were not reasonable because they would not allow him to perform the essential functions of his job, and that the evidence offered by the employer showed that the plaintiff could do his job with the accommodations that the employer did agree to provide him. These cases continue to show the fact-specific nature of this analysis and the importance of engaging in a good faith dialogue to explore possible accommodations.
Thank you, Julianne. And I'm going to talk about a few other fact-specific situations dealing with the issue of disruptive behavior. This is something that I alluded to earlier in my comments, and it's an interesting issue that we deal with in the context of mental health-related accommodations. This is probably the only type of condition that's going to result have the potential to result in disruptive behavior, and employers have to know how to deal with that. And these 2 cases that I'll be highlighting here on this slide show the context and the fact-specific nature of how those situations may come out. In the Trahan case out of the First Circuit in the Northeast, in 2020, the employee was a call center employee, also a veteran with post-traumatic stress disorder. She was in training, and her job required close collaboration with a team of other employees. And she was dealing with PTSD, and the the flare-ups or flashbacks that she would experience were sometimes the result of when she felt like she was being ganged up on by her coworkers or being criticized. And that would result in outbursts directed at her coworkers. She got into several disrespectful altercations and ultimately requested to move away from her teammates to a private office or to be allowed to work from home. Now, it's interesting, as we sit here in 2022, and we're talking about the work from home not being a reasonable accommodation. In this case, it's important to note that the court looked at that and found that the relevant facts were stemming from 2017, when the employer here would not have had any feasible way to permit work from home. It'll be interesting to think about how work from home as an accommodation for mental health or for other conditions will come out when the relevant facts are, in the post-pandemic timeframe. As a result of finding that they were not able to allow to be the close collaboration type job to allow you to be removed from your team or to work from home entirely, that would not enable the employee to do the job. Therefore, that is not a reasonable accommodation. The employer won this case on appeal. Consider the next case, how it comes out a little bit differently and how the context is important. In the CASA case, the employee was dealing with bipolar and intermittent explosive disorder. Now, the latter of which is recognized in the DSM-5 as involving recurrent behavioral outbursts representing a failure to control aggressive impulses. So obviously that has the ability to result in some disruptive behavior. The employee had previously requested and been granted by the former manager to have short breaks, to be permitted short breaks to relax and deal with the symptoms. A new manager came in and decided that that was not a reasonable accommodation and terminated the plaintiff's employment after an outburst on the phone with a client. The court ultimately reversed summary judgment. Summary judgment was granted to the employer, but it was ultimately reversed on appeal. Noting facts indicated that the plaintiff had been capable of controlling his outbursts when he was permitted to take breaks. So that will show you how the context of what has been done previously by the employer may weigh heavily in this analysis. For example, it's going to be very difficult to say that something presents a hardship or that something presents a direct threat if it's been apparently successfully given by a previous manager.
If navigating the waters of ADA compliance by employers wasn't difficult enough, you also have to analyze and assess the potential interplay of the Family Medical Leave Act. In late May of 2022, the DOL issued new guidance regarding FMLA rules as they pertain to mental health conditions. And while I describe this as new guidance, what it really is it's kind of a reaffirmation or an affirmation of what we've already kind of known regarding the FMLA and mental health conditions. One, the new guidance doesn't change anything related to eligibility or FMLA criteria. You're still going to have the same 12 months of service, 1,250 hours of service, same requirement for 50 employees within a 75-mile radius. So all those standards remain the same. Really, what has occurred within this new guidance is that the DOL has really clarified or hit on what constitutes a serious health condition within the context of mental health conditions. Next slide. And so what is that? A mental health condition is considered a serious health condition within the meaning of the FMLA if, one, it requires inpatient care, a condition that requires an overnight stay in a hospital or alternative care facility such as a rehabilitation facility constitutes a serious health condition which can warrant protection under the FMLA and require an employer to provide leave. Additionally, a serious health condition also can constitute continuing treatment by a healthcare provider, specifically a condition that incapacitates an individual for more than 3 consecutive days and requires ongoing medical treatment or a single appointment or follow-up care. If the condition's chronic, causes periods where the individual is incapacitated, or requires treatment at least twice a year, it also can constitute a serious health condition. For example, that could be a situation where an individual is attending ongoing counseling sessions related to depression or some other mental health condition. Providing that individual with leave in order to get treatment is also something that can be protected under the FMLA. So if the ADA wasn't difficult enough, you also have the challenge of dealing with the FMLA context with employees.
Thank you, Tyler. And as you all probably know, FMLA leave may be for the employee's own serious mental health condition, to care for a family member with a serious mental health condition, and to care for an adult child with a serious mental health condition, provided that the child cannot care for him or herself due to the condition. So this presents, the subjective nature of mental health conditions presents some problems for employers in assessing the reasonableness and assessing the impact. And it becomes even more difficult when it may be one or two steps removed from the employee themselves. Many of you have probably seen situations with the use of intermittent FMLA, where an employee is effectively able to use intermittent FMLA with no real drawing down of that balance based upon how much they use. So we have a few examples here. Karen is occasionally unable to work due to severe anxiety. She sees a doctor monthly for her symptoms, and she uses FMLA to take time off when she is unable to work unexpectedly due to her condition. So again, this is an example both of the intermittent FMLA usage and the fact that these types of conditions may have unpredictable or purely subjective flare-ups. And that presents just the risk of abuse and also more difficulties for the employer in assessing them. Another example is Wyatt uses 1 day of FMLA each month to travel to an inpatient facility and attend an aftercare meeting for his 15-year-old son, who has completed a 60-day inpatient drug rehab program. FMLA presents a situation where we're effectively having to accommodate something that is not the employee's own condition. And finally, Anastasia uses FMLA leave to care for her 24-year-old daughter, who was recently released from a facility for mental health condition and is unable to work or go to school and needs help with cooking, cleaning, shopping, and other daily activities. This is another example of providing an accommodation effectively due to the FMLA for a family member's condition. Julianne's going to talk a little bit about some of the resources.
Sure, Tim. So, recognizing the importance of mental health, employers have implemented a wide range of strategies to support their employees. Those resources could be, wellness newsletters, strategies for managing stress, mindfulness training, employee assistance programs, training on mental health issues for supervisors, how to identify when employees are in need of help or perhaps in crisis, and various perks related to mental health, well-being apps, flexible leave options, and they run the gamut. And while publicizing these resources is certainly advisable, an employer should take care that when dealing with individual employee concerns, you don't jump to the conclusion that an employee is in need of some kind of treatment for a mental health condition, because doing so may be construed as regarding the employee as having a disability. That concludes our presentation, and now we're going to send you over to St. Louis, where Associates Jackie Kaufman and Blake Armstrong will provide an update on Kansas and Missouri law.
Thank you so much. Good morning. As they just mentioned, my name is Jackie Kaufman. To my right is my colleague Blake Armstrong, and we're going to give a brief update for Missouri and Kansas on the state of the law. On October 4th, the Missouri Supreme Court ruled that most state employees are at will. By way of background, in 2018, a law was passed that removed most state employees from a long existing merit system, and the state also implemented regulations that removed many of the former merit system requirements. In the instant suit, 3 labor unions that were representing state employees challenged the new regulations as unconstitutional. And the basis for their challenge was that the Missouri Constitution guarantees employees the right to bargain. However, the court rejected that challenge because other terms and conditions of employment can be negotiated still other than at-will status. The significance of this ruling is that the state cannot negotiate terms with labor unions that would protect employees from being discharged without cause or would guarantee a certain term or condition of employment. However, other terms such as wages, benefits, training, and more remain fair game for negotiation.
We're also going to talk about a Kansas Supreme Court case. Again, this one was decided earlier this year on August 5th, 2022. The Kansas Supreme Court answered 2 questions from the United States District Court for the District of Kansas. A little bit of background here. Again, a former superintendent of the Kansas Highway Patrol filed a 1983 action alleging their refusal to return him to rank. So the significance here is that the District Court, in a rare move, sought clarity from the Supreme Court of Kansas, and this is a pro-plaintiff ruling. But a key piece of significance here is that this is for public employers only. So the 2 questions were, then the court held that the employee's ranking fell within the classified and civil service system to receive the right to guaranteed continued employment. So again, the guaranteed continued employment is very significant here, but it is limited to the public employers and that specific classification. The second question that the court answered is that the court held the former KHP superintendents or assistant superintendents are not required to serve another period upon returning to their former rank in classified service. Again, both of these were pro-plaintiff holdings, and both of these questions were answered by the Kansas Supreme Court at the request of the District Court of Kansas. And while they are pro-plaintiff, they are limited to public employers for this specific classification.
We also wanted to highlight one pending Supreme Court case that we will be watching closely. This term in In re Grand Jury, the court will clarify the standard for determining whether attorney-client privileged communications are protected. As you all know, often attorneys advising on labor and employment matters will offer blended legal and business advice. And this decision is anticipated to clarify what types of information are going to be protected from disclosure.
So next is a 10th Circuit case, again, relevant for those in Kansas. And the key emphasis here is on due diligence. So there was multiple sales of a company. In this case, it was a hotel. And the EOC filed a complaint. And later on, they amended the complaint to name each successive owner, each new owner after the sales. And the 10th Circuit held that the successive owners could be liable for employment discrimination. As you can see at the bottom, they were afforded 30 days to perform due diligence, and they should have conducted that due diligence. And so a key thing that we want to emphasize here is that when you are purchasing entities, to do that due diligence, because you could be held liable for past EEOC discrimination cases from the previous employer.
Yes, and as a quick update, speaking of the EEOC, they have updated the workplace posters on employee rights. This is as of October 20th of this year. They issued a new Know Your Rights poster. Covered employers have to display this poster in a conspicuous location. And a covered employer is one that is covered by an EEO law, so one that has 15 plus employees. And there's a link on your screen that you can follow to download those posters. There's one in English and one in Spanish. Yes, and also by way of brief reminder, I believe most of you are aware of this, but on the 1st of the coming year, the state minimum wage in Missouri increases to $12. And this was approved by Missouri voters in 2018. And this is the final raise under that.
So next, we're going to talk about a new rule for the independent contractor classification. So in October of 2022, the DOL published additional ruling, and this goes a little bit against in rescinding the rule from 2021. So in 2021, there was a rule that allowed significant weight to be given to 2 factors: the nature and degree of workers' control over work and the opportunity for profit and loss. So the new rule, as of October of 2022, is that these 6 factors will be given equal weight. To go through those 6 factors, which I'm sure most of you are aware, it's the nature and degree of a worker's control over work, the worker's opportunity for profit and loss, the relative investments of worker and employee, the performance of the working relationship between the worker and employer, the degree of skill needed to perform work, and the extent to which workers' duties are integral to the business. So again, the likely result as we move forward here is that more individuals will be classified as employees. So that's something that, again, just to keep an eye on as we move forward, that as of 2021, when doing this analysis of employee versus independent contractor, I'm sure most of you would have been giving a little bit more weight to those two as of the 2021 rule. Moving forward, we believe the result will be that the significant or the equal weight will be given to all 6, and that's how we should move forward with that.
Great. So in just a moment, we're going to be handing it off to Ben, Kelly, and Eleanor in Kansas City.
So we are working on fixing the audio in Kansas City right now. We'll be moving back to Kansas City in a moment. We apologize. Just bear with us for a couple minutes as we get the audio rebooted and fixed in Kansas City. Thank you.
Thank you for your patience.
Go ahead. Okay, we'd obviously like to apologize for the technical difficulties that we've encountered here in Kansas City. We're doing our best to kind of throw something together here so that we can still get you all the content that you're here to listen to. It's my pleasure to be here today to talk with all of you. I'm going to be joined by a couple of colleagues who will, I'll leave them the opportunity to introduce themselves. We're going to be talking today about kind of a tricky topic, and that's crystal ball predictions from the midterm elections. Now, the midterms didn't go certainly as I think a lot of the pollsters thought they would. I think certainly to the chagrin of the Republicans, they did not take control of the Senate. I know the House is still up in the air. It seems like that's going to end up going the Republicans' direction. But regardless, we're going to do our best to give you not only some updates from what has happened recently, but also maybe some predictions of given the current makeup of the House and Senate, of the direction we think some of these laws and administrative actions and trends might be heading. Before I do that, my name is Ben McMillan. I'm an attorney here in Kansas City with Husch Blackwell. I've been here my entire career, 12 years. It's probably my 10th seminar. I always enjoy the opportunity to get up in front of you all, even when it's virtual and even when we're having technical difficulties. but to kind of share some things we've been working on and to give you guys some tools to help you do your job better. First, we're going to go through some federal updates. We're going to talk about unionization, which, as we'll see, is actually on the rise. Then we're going to get into the continuously, I should say, difficult area of Section 7 and concerted speech and how that relates to concerted activity under the NLRA. We're also going to look at some potential federal developments under the EEOC and the always looming legislative activities related to abortion, cannabis, and minimum wage. Finally, I'll be talking to you about some controversial opinions before the Supreme Court involving affirmative action in college admissions and how we think that might reach out into the employment law space. We're also going to be talking about election developments in Missouri and also in Kansas. Missouri passed a law about Amendment 3 regarding the use of cannabis that we think is certainly something you need to be kept abreast of. And also Kansas. Governor Kelly was reelected, but the election of Attorney General Chris Kobach might signal some change that you all ought to be in tune to. So moving forward here, I want to talk to you first about unions. The workers of the world, or at least in the United States, are indeed uniting. Union elections are on the rise. That is certainly contrary to, I think, what most folks believe is the current union environment in the United States. Unions won around 700 victories between January and June of this year. That's the most total victories since 2000. They also have the highest winning percentage they've had in a very long time at about 75%. Notably, many of you probably saw this, and this might affect some of you directly. Amazon, Apple, Chipotle, REI, Trader Joe's, and some other well-known companies fell victim, I guess you could say, to successful union campaigns. In addition, anti-company sentiment within unions seems to be up. Strikes tripled in 2022 as compared to 2021, and some sources suggest that public approval of unions is at its all-time, or is at a 50-year high. Now, why is that? A lot of different factors go into that. It could be, and my opinion is, the political environment generally in the United States is contentious at the moment. The meter could be ticking more toward a favorable view of workers and workers' rights in light of the heated political discussions that have gone on, and that could contribute to, frankly, even an unfairly pro-worker sentiment among the general population. So what does the future hold? Interestingly, I think, are the Section 7 developments regarding concerted speech. Now, when we talk about concerted speech, we talk about speech related to concerted activity. Concerted activity obviously involves the right for employees to come together to represent themselves to their employer regarding the terms and conditions of their employment. Now, I will tell you the most common misconception that I have seen among clients is the idea that if you are not currently a unionized environment or unionized workforce, that the NLRA does not apply to you. That is not the case. All companies engaged in interstate commerce are subject to some of the NLRA's regulations, and that includes concerted speech. Now, thanks to the FDR court of the New Deal era, that could so much as be you selling lemonade on a corner in your neighborhood. That could potentially reach out into interstate commerce. So if you're under the belief that the NLRA does not apply to you or your company, I would disabuse yourself of that notion. You certainly need to be kept in the loop on these developments. So at issue right now is the question of whether political speech, and in particular in this case, the wearing of a mask that says BLM, is protected concerted activity that could pertain or relate to the terms and conditions of employment. The case at issue, or it's currently a ULP that the NLRB is pursuing. Jennifer Abruzzo, the new GC, is pursuing a ULP with the theory being that Whole Foods prohibition, it was a neutral rule regarding slogans, logos, what have you on masks, that the company was going to prohibit that masks just needed to be neutral as to all content. That was an overreach that invaded the employee's right to engage in concerted speech, and specifically here, political speech regarding discrimination that might impact the terms and conditions of employment. Now, that would be a significant development. The good news for employers is Home Depot had a similar case before an administrative law judge that went the employer's direction, that said, no, that is appropriate. That's not an invasion of an employee's right to engage in concerted speech regarding the terms and conditions of employment to prohibit the inclusion of a slogan like that on a mask. So it's a very interesting development. We're not really sure how it's going to go, but with the Democrats in control of the Senate and the overall pro-employee sentiment that seems to be there, this could be a very interesting development for employers to be cognizant of, for sure. With that, and again, we're going to have to kind of shuffle in and out of the screen here. I'm going to turn it over to my colleague. I'm going to allow her to introduce herself.
All right, good afternoon, everyone. My name is Eleanor Kittelstad. I'm an associate with the Labor and Employment Group, and I'm going to continue the discussion of potential federal developments. Starting with the EEOC, we are predicting that we may see some sexual harassment guidance come out of the EEOC in the future. The current chair is Charlotte Burrows, and she has indicated her intent to put forward sexual harassment guidance that was initiated during the Obama administration and then stalled during the Trump administration. Given the election results in the Senate with Democrats maintaining majority control, it is likely that current nominee Kalpana Katagal will be confirmed by the Senate and become a commissioner with the EEOC, which will then create a Democratic majority in the EEOC. If that happens, it's more likely that sexual harassment guidance will be forthcoming. A couple interesting points about that guidance. First of all, the original guidance that was put forward under the Obama administration included the position that has now been adopted by the Supreme Court in the Bostock case, that Title VII protects against discrimination both for sexual orientation and gender identity. So that is likely something that we will see if sexual harassment guidance comes forward. Another thing just to be aware of is that between the time that the guidance was initially drafted under the Obama administration and now, we have seen the explosion of the Me Too movement. So there may be some ways in which any new guidance will incorporate some of what we've been seeing with the Me Too movement. Moving on to legislation, I'm not going to spend a lot of time on this point, given the election results and the House likely being governed by Republicans while the Senate is in the control of the Democrats. We're less likely to see legislation on some of these hot topic fronts like abortion, cannabis, minimum wage than we may have been if Republicans had done as well as was anticipated in the midterms. It's possible that we will see some legislation on the cannabis front. There's some bipartisan efforts. Much less likely that we will see anything with regards to abortion or minimum wage. One thing I did want to note, however, about abortion is that employers should be on the lookout. The EEOC has recently filed 3 charges against companies who offer abortion travel policies. The charges were brought by the commissioner, so that's a little bit unusual. Typically, we see an EEOC charge brought by an individual, investigated by the commission. In this case, these charges were brought by the commissioner. They allege that abortion travel benefits discriminate against pregnant employees and employees with disabilities because the programs do not offer equivalent benefits to those employees. So that's just something to be aware of. These are relatively newly filed charges. We don't know a lot about them yet, but what comes of them remains to be seen. So that's all I'm going to say with regards to legislation. I'm going to kick it back to Ben to talk about Supreme Court developments before we get into the state midterm elections.
Thank you, Eleanor. I'd like to talk with you now about some developments before the United States Supreme Court. No, thank you. So to the extent you followed it on Halloween of this year, there were 2 cases argued before the Supreme Court regarding affirmative action in the use of admissions processes, I should say, at our colleges and universities. The first was a case against Harvard, and that was argued under Title VI. It prohibits discrimination. That's a federal law prohibiting discrimination in that context. The second was a case argued regarding the use of those programs at the University of North Carolina. Now, given that that is a state institution, the crux of that argument is that the use of race consideration in the admissions process is a 14th Amendment violation, specifically the violation of the Equal Protection Clause. Now, you might be asking yourself, "Hey, I don't work in the education space. How does this affect me?" Well, we think it's conceivable, given the current nature of the court, and specifically its conservative bent, that the rulings in both of these opinions could be far-reaching. And it is my belief that that the use of affirmative action, certainly in the context of higher education, could be doomed. I think the court could be headed toward almost an entire broad sweep, saying that this is unlawful under both Title VI and under the 14th Amendment. We do know the businesses have chimed in here. There was an amicus brief filed by the HR Policy Association, major American business enterprises, arguing in favor of these programs, saying these programs at our colleges and universities help us achieve our DE&I initiatives here at the corporate level. Now, again, depending on how wide-reaching the scope of the decisions are, those programs could be in jeopardy. So we would urge you all to keep a close eye on that. We'll be certainly watching it closely and look for an update from us, regardless of the outcome of those decisions. There's one additional case I want you to talk about. It's under Colorado's law that prohibits discrimination against folks in public accommodation or in public settings. You all might have heard of the cake maker case in Colorado, where the Supreme Court ruled more narrowly that law was an overreach and a violation of the First Amendment. That this individual who made and sold cakes for weddings could abstain from selling those to couples that were going to have a gay wedding ceremony. There's a follow-up case, a graphic designer who's claiming that being forced to provide that content for a same-sex wedding violates her religious beliefs. So employers need to be cognizant of that. Depending on how that case ends up, you could see a trend toward employees abstaining from certain duties in such context based on a religious exemption. So with that, I'm going to turn it back over to Eleanor, who's going to talk to you about developments in Missouri.
All right, so we're going to talk about Missouri Amendment 3, which legalized marijuana in the state of Missouri for recreational use, I should say. What I really want to talk, though, about is the new anti-discrimination provision that was added to the Constitution with respect to medical marijuana use only. So this anti-discrimination provision does not apply moving forward to recreational users, but will apply moving forward to medical marijuana users. So what does the provision say? It applies to hiring, termination, and any condition of employment. It prohibits discrimination against any person using medical marijuana or who has a positive drug test showing marijuana components. This will take effect on December 8th of this year. And I should note that although this is an anti-discrimination provision, it is not an accommodation provision. So it does not require employers to accommodate the use of marijuana in the workplace. It does not require employers to allow medical users to either be under the influence of marijuana while at work or to use marijuana while at work. This also does not in any way curtail an employer's ability to require drug testing. And so employers in both Missouri and Kansas will have to think about how they want to handle drug testing moving forward based on individual business needs. One thing to note that the Missouri statute does not, or I should say the Missouri Constitution, this is a constitutional amendment, one thing it does not address is how an employer is to know whether someone is under the influence of marijuana at work. The statute doesn't provide any guidance. So typically it's hard to make generalizations about these sorts of things, but employers can look to observational characteristics as a starting point. We can look at other states for guidance. For example, in Illinois, employers can make a good faith determination that employees manifest specific articulable symptoms that indicate an employee is under the influence of marijuana. And then their statute specifically lists out symptoms like speech, demeanor, or coordination impairment. So those are some things that employers might want to be thinking about, and we don't yet have a lot of guidance on that. But what you do need to know at this point is the anti-discrimination provision will come into effect on December 8th of this year. And I'm going to turn it back to Ben now for a Kansas update.
Thank you, Eleanor. The Kansas update is going to be short and sweet. Governor Kelly won re-election. We expect her to pursue the same policies that she had pursued previously regarding the Kansas anti-discrimination agencies. We don't anticipate any real surprises there. What could get interesting is the election of Chris Kobach as the Attorney General. Mr. Kobach is a bit of a maverick. There's kind of a new sheriff in town, so there could be some interesting challenges to different federal laws and regulations, specifically OSHA, things of that nature. Difficult to predict, obviously, but we've done our best. Okay, that concludes Eleanor and I's portion of the presentation. We hope you've enjoyed it. I'm going to turn it over now to my friend and colleague, Kelly Mylink, who's going to talk with you about all things immigration.
So in keeping with the trend of crystal ball predictions and going back and thinking about the Kansas elections, I'll mention just one thing. The election of Chris Kobach. Chris Kobach is a very influential figure in immigration. So when I think about the list of state laws that I keep on my radar, Missouri's on that list, California's on that list. I'm adding Kansas kind of back on my watch list as an immigration attorney to kind of see, well, what's going to happen in Kansas, particularly with the election of Chris Kobach, since he's kind of that national name in immigration. But so we're just kind of keeping a look at those state level laws in immigration to see kind of what happens. On a broader scale is really what I want to talk to you all about today. So I'm Kelly Mylink. I've been practicing immigration law for a decade now, and I primarily work with businesses, and I work on sort of the corporate immigration compliance and visa side. And that's really what I want to focus on in the last sort of few minutes of our segment. We're talking about changes at U.S. citizenship and immigration. Midterms, we have kind of divided Congress. Likely, we're not really sure yet, but let's say we don't really have any super majorities, so we're really not going to see any big changes in immigration law. What we will see is maybe changes at the agency level. U.S. Citizenship and Immigration Services, under its current leadership, is really on its sophomore season. So we've had a director there who's in her second year, and we are seeing, or his director in the sophomore year, so we are seeing sort of some changes kind of come into play here, right? So two things. One is the backlog of immigration cases that have been historically plaguing employers and their employees waiting to get their applications to process. It's really not going to move very much faster. But what the current U.S. Citizenship and Immigration Services leadership wants to do is sort of put some Band-Aids on that backlog to kind of maybe we can move it along a little bit. One of those is the expansion of the premium processing program. So the premium processing program allows for applications to be expedited by paying an additional fee. If you are an employer who sponsors employees for H-1B visas, you might pay that $2,500 and get a decision in 15 calendar days. The idea is to expand that program to other visa types that weren't necessarily eligible for that program before. The second one is this expansion of the automatic extension of work authorization from 180 days to 540 days. So what this is if you are an HR professional, you probably are plagued with this issue on I-9s quite frequently. When an employee comes to you, they might come to you with work authorization documentation in the form of a work card, and that work card could be expired. And then that employee brings to you a document that says, hey, I filed to extend my work card another, but I just I don't have the new work card in hand yet. So they've got an expired work card and a receipt for a new work card and are still waiting for it to come in. Well, the current policy was they had 180 days of continued work authorization beyond the expiration of their card if they qualified. Because of the backlog, USCIS extended that to 540 days. So that gives you an idea of how long that backlog really is. So those employees might have a work card that expired over a year ago, a receipt showing a filing of a petition to extend their work card that was filed over a year ago, and they still might have work authorization for another year. So it gives you an idea of how big that backlog is. And the idea is let's keep these employees so that employers aren't having to deal with a 2-month gap in employment authorization where they have to, terminate the employee and then rehire them once their card comes in. There are some backlogs in the consular appointments. So employees who are abroad trying to get their visas, it's taking a long time to get those appointments at the consulates too. That really hasn't changed and isn't likely to change. Another thing, the second thing that I want to talk to you all about today is the Form I-9. So Form I-9 is how employers verify the identity and employment authorization of all employees. If you are an HR professional, you might be a little bit nervous because you're using a Form I-9 that is currently expired. That's right, it's still valid, even though the I-9 says it expired on October 31, 2022. You can still use this form. We don't have the new version yet, but we are looking in the next few months for that new version to come out. It will likely be simplified. We're hoping for some potentially maybe compressed onto one page, which would be really helpful, an updated list of acceptable documents to guide employers. So we're hopeful to see that here in the coming months. So keep your eyes out for that if you are currently working through the I-9 process for your organization. The second thing that I want to quickly mention is there are some efforts in place by USCIS to expand some of those COVID-19 related flexibilities related to the Form I-9. So during COVID, there was a period of time where employers could verify the employment authorization and identity documentation remotely. Under the normal rules, you have to verify that documentation in person, which is really, really hard when you have remote workers, right? How are you going to review in person their physical documents, their ID, their social security card? And so what USCIS said, we hear you, we understand that you really enjoyed having these COVID-19 related flexibilities to allow for the remote verification of your documentation. And they are now contemplating a pilot program that would put this in place either more permanently or for employers who meet certain conditions, who go through an hour-long training. All of that is being decided on by USCIS right now. They have at least some proposed regulations out there saying we're thinking about this and we want to put this into place in some way, shape, or form. So we're anxious for that. We know it'll be a huge help for employers who have that remote workforce. So with that is the best crystal ball predictions I can give you on immigration. Ben, do you want to finish us up with a poll?
I certainly do, Kelly. I'd like to again apologize for the difficulty we've had with technology today. Our poll question is going to be a little more fun, and that is who is your favorite non-Patrick Mahomes Chiefs player? Our options are Travis Kelce, the greatest tight end ever, Missouri Tiger Nick Bolton, Juju Smith-Schuster, and sack master Chris Jones. I'm not going to tell you mine because I don't want to interfere with your own selection, but take 30 seconds here, let us know, and then we will conclude our presentation. All right, think carefully about this. And again, we apologize for the technical difficulties. Very important question. All right, I believe my next step here is to click over to the next slide. To get a little help on this here. Okay, let's go back here and see how it went. Travis Kelsey, no surprises there. I agree with you all. Thank you for your participation. And now with our final, most important prediction of all, it is that the Kansas City Chiefs will host the Lombardi Trophy above their beautiful red helmets after this year's Super Bowl. I am as confident in that prediction as I am in any that I gave today. Thank you all for listening. We hope it was helpful. We hope you had a little bit of fun. I'm going to turn it over now to my colleague in St. Louis, Brittany Falkowski, who's going to be talking to you about COVID-19. Thank you all very much.
Good afternoon, everybody, and thank you so much to Ben, Kelly, and Eleanor. We're about halfway through our presentation this afternoon, and if anybody sees the title of my presentation and wants to take this opportunity to take a break, I would not blame you. I know that people are getting sort of exhausted by constantly talking about COVID-19, and here we are wanting to talk to you about it a little bit more. I can't promise that it will be painless, but I can promise that it will be quick. We just want to give you a little bit of an update here, especially as it relates to some EEOC guidance that was issued back in July, as to when COVID-19 can be considered a disability under Title I of the ADA, which does obviously include some accommodation and non-discrimination requirements, as was discussed in our earlier presentation. So before we really get into what the EEOC has said, let's level set. And let's make sure that we all understand what's meant by long COVID or post-COVID. Sometimes it's referred to as long haul COVID, or people who have it are referred to as long haulers. And really what is meant is that, you know, you can be experiencing any number of symptoms, and a lot of them are listed on this slide, not all, because they honestly wouldn't all fit, but you experience them for a period of 4 weeks or longer. And really, I think one of the things that's interesting to remember is that these symptoms can come and go. It's not like they have to be consistent throughout that entire period. Again, the list is not exhaustive, but it's also very varied. It can come anything from fatigue all the way down to depression or anxiety, which was also mentioned in that earlier presentation. So this is what we mean when we're referring to long COVID. And one of the things that we want to ask is, you know, when can long COVID be a disability such that then you would have to comply with the requirements of the ADA and other state counterparts? Well, the EEOC did update some guidance back in July, and kind of no surprise, the EEOC basically took what is relatively new, COVID, and placed it into its old framework of what constitutes a disability under the ADA. So long haul COVID can constitute a disability if you meet the definition of disabled under the ADA, meaning you either actually have a disability, you have a history or a record of a disability, or you're perceived as having a disability. One thing to note is that if you have mild symptoms that resolve relatively quickly, it's not going to be a disability that needs to be accommodated. And so that's helpful for us to remember when we have employees come to us and ask, you know, for accommodations related to their COVID-19 symptoms. Another thing to remember that the EEOC said was that COVID can exacerbate pre-existing conditions. So a condition that perhaps was not a disability or didn't meet one of these definitions before someone had COVID can lead to them meeting the definition afterward. So I want to go through a quick hypothetical to kind of just show how this can play out. Here in this hypothetical, I apologize, all of the pictures that I'm using are pretty, well, depressing themselves. So hopefully, you know, if you did take a break for this presentation, again, I totally understand. But in this hypothetical, Anna was diagnosed with COVID-19 4 weeks ago. So that's kind of the timeline that we talked about earlier. Currently, she's experiencing intermittent multiple day headaches, dizziness, brain fog, and her doctor's attributing these symptoms to her COVID-19. So the question is Anna disabled? Well, as you could probably guess, the answer is maybe. If she actually has an actual disability, meaning that her major life activities are substantially limited by COVID, then perhaps. And so if she does meet that definition, what should her employer do? Well, this one, I think, just also, again, should not come as a surprise, but we want to follow our normal ADA interactive dialogue procedures. We want to first determine whether Anna is a qualified individual with a disability. Is she somebody who we can reasonably accommodate in a way that will allow her to perform those essential functions of her job? That's going to require an individualized assessment You can get medical documentation if you need to either establish that she has a disability or understand the nature, severity, and duration of her disability, and that will all help you determine whether you can reasonably accommodate her. If the accommodation that she requests or that you come up with is not reasonable or would constitute an undue burden, which is again a really high bar, or would present a direct threat to the health and safety of others, then you wouldn't necessarily have to accommodate under those circumstances. So I know this is all just kind of a refresher, and it's really things that you are all very familiar with doing by now, but just a reminder to everybody that if you have an employee who has long haul COVID, then make sure that you're running through this analysis and treating them as you would anybody else who requests a reasonable accommodation. So that's it for our quick update on long haul COVID and the legal implications. I'll kick it back over to Kansas City to Courtney and Rachel.
Thanks, Brittany. Good afternoon. My name is Courtney Steelman, and I am joined with my colleague, Rachel Kim, and we're attorneys in the Labor and Employment Group here in the Kansas City office. Today, we're going to give you a brief update on the Crown Act and how it may impact your business. So first things first, what is the Crown Act? Crown is a national campaign by the Crown Coalition of Businesses and Organizations. Crown stands for Creating a Respectful and Open World for Natural Hair. The pending national act and various state acts aim to prohibit discrimination on the basis of hair textures or styles if they are commonly associated with racial and ethnic identities. Currently, there is a federal bill pending in the Senate, which has already passed the House. Now, why is this important? Research has shown that, for example, Black women are expected to alter their hair to fit in at work or have been rated less ready on job performance measures. The various Crown Acts aim to help address this issue. For example, in New York, they have amended their human rights law to cover discrimination on the basis of hairstyle as a form of race discrimination. Part of the statute actually states Black hairstyles are protected racial characteristics under the statute because they are an inherent part of Black identity. 19 states have either passed a Crown Act or have amended their human rights laws to prohibit race-based hair discrimination. However, Missouri and Kansas are not included in those 19 states. Important for employers, though, some of our surrounding states have passed legislation including Nebraska, Colorado, Tennessee, and Illinois. Currently in Kansas, there is very little traction and no pending legislation. However, in Missouri, there have been variations of the Crown Act introduced. All those have been in the past and they've failed. But most recently, Missouri had a piece of legislation that would have prohibited discrimination on the basis of hair only in state-funded schools. And this bill did not mention employers. However, city ordinances in both St. Louis and Kansas City covers all employees, and they have passed. In St. Louis, the ordinance also explicitly states that it covers labor organizations and employment agencies. The Kansas City ordinance was signed into law on October 2nd, 2020, and the St. Louis ordinance was signed into law on May 7th, 2021, which of course covers City of St. Louis and St. Louis County. It's important to also note that in Kansas City, quote, traits historically associated with race is also included in the language, which means it opens the question as to what other traits will be subject to the same protection. And now over to Rachel with how it can impact your business.
Thanks, Courtney. I'm Rachel Kim. I'm an associate in our KC office in our L&E practice. So what does this mean for employers? What can you do to ensure compliance under local, state, and federal law? And even if you're not a Kansas City or City of St. Louis employer or operate in any of the states that have passed Crown Act related legislation, it is important to exercise caution as a court may accept the argument that hair discrimination is a form or even evidence of race discrimination, which we all know is prohibited under state and federal law. So there are steps that you can start taking as early as today to ensure compliance. First, take a look at your policy language related to dress code or appearance. Are there any categorical bans on hairstyle under your policies? For example, blanket bans against dreadlocks, afros, braids, cornrows, etc., should receive a closer look. Second, offer relevant training to employees with supervisory and/or hiring authority. Train your supervisors. I can't emphasize that enough about the prohibitions and the information that Courtney and I shared with you today. Your supervisors and your hiring authorities are the company, and thus the decisions of your supervisors and hiring authorities are the actions of the company. It's essential that they are trained on the local ordinances and the information that Courtney and I shared with you today. Well, Courtney and I enjoyed spending this time with you. I'm going to pass it over to partners Kate Copen, Randy Thompson, Joe Glanius over in our St. Louis office, who are going to talk to you about lessons learned from verdicts and settlements. Thank you.
Hey, just kidding, everybody. I'm sure a lot of you were probably about to send out there saying, I'm not going to spend the next 90 minutes listening to this. I didn't make it to the beginning of this, but I understand we had a few sound issues, so thought we'd get that cleaned up for everybody. So hopefully you're all still with us. I'm Randy Thompson. I've got Kate Copen and Joe Glanius with me today, and we're going to talk to you about the recent verdicts. And fortunately, we don't find a way. So this morning, here in the state of St. Louis with the car dealership. So clearly these cases are still going on, and we're not going to go back. We're going to try to give you some practical advice today on how to navigate these cases. We get the mitigation and the cost. This, to make a bad joke, was really a case about a new sheriff in town. In this case, the plaintiff was a security officer. And I just to get the facts in this case is going to show why we might have $6.9 million. Got plaintiff who was working for 33 essentially stop this. Not really good. And then we get a new sheriff that comes in town, and suddenly there are allegations of misconduct, and one of the things in there was the timing of this happened so soon after the allegations. This one was in Jackson County. That is a very pro-plaintiff jurisdiction. Very challenging when you get a case that's in Jackson County before those juries, and particularly against the police department. Not really surprising that you might have an adverse verdict. Now, of course, $6.99 million is pretty extreme on this. A couple of things that I think that my takeaways from this case were, and this comes up in a lot of cases that we have for clients, which is you may have a plaintiff that had been there for some time. Maybe the performance wasn't great, but not the best performer, probably not the worst performer. But you get new management that comes in and they say, look, we want to clean up a little bit. We want to raise the standards. That may have been the case here. But the challenge on these cases then is to how to navigate that. And you can't just come in with a 34-year employee and say, we're going to clean house. You need to get out of here or else. In particular, when we have somebody who has a relatively clean record and then suddenly there are allegations of misconduct. Even if those allegations have some substance to them, again, here, going through the disciplinary process probably would have been in order. We didn't have good evidence here that was the case. So my takeaway, the bigger takeaway from this is really on the timing element is, as you see on here, to be careful to take the adverse action in close proximity here. We always have to be mindful of it, and we counsel clients all the time on the timing issue of this. And sometimes that requires a little bit more of a lengthy process on this, even when disciplinary action is warranted. The other piece on this too, and you get this in Missouri a lot, is there was a lot of Me Too evidence on this case. So Missouri, particularly in the state courts, are very broad in allowing the Me Too evidence. And in here, there were a lot of cases where other individuals, not just the plaintiff, were indicating, hey, you need to, when are you going to retire? You need to leave out of here. So again, not very surprising that he got the verdict in this case.
Okay, so next case here is mine. This is an interesting case. We're going to have a couple of these that you're going to hear about today, where there are some lessons to be learned, some best practices to take from it, but you wonder if the court really got it right. This one is not done yet. As I'll talk about here in a little, it's not gone completely final, but the facts are still instructive. So in this particular instance, Howard versus City of Sedalia, the defendant was a hospital pharmacy, goes by the name Bothwell, for those of you who live on the west side of the state. They hired, well, in this particular pharmacy, by the way, there were sterile areas where certain medications were prepared and everything was kept very clean. And then just regular sanitary areas where, again, standards of cleanliness were high, but not so far as to call them sterile. The employee, the plaintiff in this case, Ms. Howard, was hired in mid-2020, and she's a type 1 diabetic. Right after she started, she did say that she needed a couple of reasonable accommodations, the ability to have food and drink at her workstation, which the employer accommodated. Shortly after that, she got clearance for and was going to be given a service animal, a service dog, that was going to be able to monitor her insulin in her body and alert her when it was going low. She came to the employer asking to be able to bring the dog into the workplace, and the employer immediately had some concerns. As I mentioned before, several areas in the pharmacy are sterile, and there were concerns that having the animal in the pharmacy could in some way endanger that. But that being said, the parties did sort of work together collaboratively, certainly in the beginning. The employee indicated that she would be able to only keep the dog out of keep the dog out of the sterile areas, keep it in the non-sterile areas, and would only even need the dog in the workplace for about 6 months. And then after that, the dog would be trained and could stay at home when she was at work. Like I said, the parties engaged in a collaborative process and really went through the interactive process from that point. For the employer's part, they solicited opinions from a variety of different organizations, licensing boards, health associations, yada, yada, to assess what the potential risk would be to the sterile environment that they need to maintain. They also spoke with some boards that would audit and review the pharmacy from time to time to make sure that the license was appropriate. And there was even a communication from that board that if they were to find a service animal in the facility, they would cite them for a violation. For the employee's part, she offered all kinds of different mitigating measures. She would put booties on the dog. She would clean the dog on a more regular basis. She would crate the dog when she goes from the sanitary part to the sterile part, which was on a fairly infrequent basis during her shifts. She would brush the dog more regularly to keep it clean. And this went back and forth for some time. The employer offered her a variety of different positions where she could work and have the dog with her at all times. She did not want them, some of which for some fairly meritorious reasons. Others, I would say, were not quite as well explained. Ultimately, I should mention, by the way, this went on for months. The employer kept her on paid administrative leave the entire time as they tried to figure it out. Ultimately, the employee decided, you know what, I'm not going to do this anymore. I think now that the employer is not doing this in good faith, and I'm going to go ahead and quit. She went ahead and quit. She got another job working at another pharmacy where they did allow her to keep the dog with her at all times, and she filed the lawsuit. Ultimately, the jury returned a verdict of about $115,000 of back wages and about $18,000 of emotional distress as part of the award. And so the takeaway here really is you can never really do enough sometimes in this interactive process. You really don't want to be quick to jump to the conclusion that you can't accommodate someone. Like I said, this is not over with. The defendant in this case has filed a motion for new trial and likely will appeal. So my hope is that it will prevail, because I really do think they took enough steps to meet the legal standard. But it's just a good lesson that you have to really be exhaustive in the way you approach the interactive process and possible accommodations.
All right, so I'm going to talk about Hunter versus Harley-Davidson Motor Company. This was a case that was decided last year. So the plaintiff, Gloria Hunter, she worked for the company for about 20 years, was an hourly employee. During the last 3 years of her employment, she got promoted to a team lead. And when she got that promotion, she then started working for a new manager. She and her manager had a bunch of different conflicts, and she made 4 different complaints to Human Resources during those years about him. That he was micromanaging her, that he was asking her to perform tasks that other team leads weren't asked to perform, that he was interfering with her ability to work overtime, that he was just overly critical of her and spoke to her in a negative and condescending manner. Every time she complained to HR, the HR department did investigate. The plaintiff was concerned that her manager was treating her differently based on her race. She was African American, and her age. And she alleged that other team leads who were younger or non-African American were treated differently. So, like I said, the HR department did investigate all 4 of her internal complaints. Ultimately, the company did not find that her manager or anyone else at the company was taking any action on the basis of her race or her age. But on at least one occasion, they did find, based on their anti-harassment policy, which went above and beyond what the law requires, which of course is how companies should word their anti-harassment policies, that his language or interactions with her, could have been improved and weren't totally acceptable under the policy. The problem was the company did not counsel her manager on his interactions with her and his language and his professionalism. So ultimately, the jury returned a verdict for $4.6 million, $3 million in compensatory damages, $1.6 in punitive damages. Of note was that the manager testified during the trial that if the company had told him to change his behavior and change the way he was interacting with the plaintiff, he would have. So that was probably a big factor in the jury's decision. So, the takeaway of this is all complaints need to be investigated, which the company did in this situation. But, if there's ever an instance where a manager is found to be violating a policy or even where his or her behavior could be improved, that needs to be documented. The individual needs to be counseled on it, because in this case, the jury just was left with this feeling that the company let this go on for 4 years and continued to allow the plaintiff to be subjected to that behavior. So again, make sure that whenever your HR department or anyone else is doing an internal investigation, there needs to be appropriate follow-up with the individual who is the subject of the complaint and proper counseling to improve that behavior and make sure that is documented as well.
Next case that we are going to talk about is Hartman versus Astellas Pharma. And I'll tell you at the outset, this is a great example of how people and juries interpret cases. So by the time you get to a trial, it's about fairness and right or wrong. Sure, the juries will look at the claims and they'll read the jury instructions, but I can tell you from my experience, they are going to look at fairness on this. And this is a case where I believe, from everything I've seen, that the jury felt that the plaintiff was treated unfairly. When you look at the case, the facts aren't really that unfavorable to the employer in this case. In this case, the plaintiff was a pharmaceutical sales rep for the defendant. Had worked there for several years, and ultimately the plaintiff was discharged for alleged off-label marketing. And in off-label marketing, what that means, and it's a very serious in the pharmaceutical industry issue, means you are only allowed to market a pharmaceutical product for what the FDA has authorized you to market. And it's frequently, there might be other benefits from a pharmaceutical drug. There we go. Sorry, everybody. That time you weren't getting sound from me, and I actually wasn't trying to joke about it. Okay, thank you. So in this case, the plaintiff was fired for alleged off-label marketing. So oftentimes in the pharmaceutical area, there might be other non-authorized benefits for the drugs. And so routinely these come up, and it's not uncommon for a sales rep to be let go if there's alleged off-label marketing in that. So it's a pretty serious allegation. But in this case, the jury awarded the plaintiff $4.4 million. Part of this was for age discrimination, and part of it was for a service letter claim. Now, again, I told you the facts really weren't that bad for the employer. The plaintiff was 40 years old. So the plaintiff was, the youngest that you could be protected under the age discrimination laws, and yet got a 7-figure verdict on that claim. And then there was a $2 million verdict on a Missouri service letter claim. Now, for those who practiced in this area or work in this area, you may remember a service letter, but very rarely, they never come up in litigation, and they certainly never go to a trial. And the service letter claim, you're required under this quirky Missouri statute to provide, in response to a request, the dates of employment, the positions held, and the nature of the services performed, and the true reason why you were let go. And you've got 45 days to provide that response. And the historic purpose of that was to give the person basically a referral so they can go find another job. In the real world, it's just something that plaintiffs' lawyers use to try to pin down a defendant or see if you don't respond, because you can't get punitive damages based on the content of a service letter. So you can be wrong in a service letter. You just have to provide the service letter. And in this case, the plaintiff argued that the employer provided what the position was, but didn't give the nature of the position that the plaintiff performed. And the jury gave $2 million on this. Now, if you dig a little bit deeper into the case, there was evidence in here that during the investigation, the defense used outside counsel. Outside counsel were very predetermined in their result. The investigation was very offensive toward the plaintiff, very conclusory and presumptive toward the plaintiff. Again, a lot of evidence here that the plaintiff wasn't treated fairly on the case. And so you look at a case where you read the facts and you say, well, how can that happen? But it's a friendly reminder, if you can, hit that, is you have to be fair in the process. In this case, the plaintiff even testified to some, in the testimony that would have probably supported the discharge under different circumstances. But I think the jury just said, look, we don't think this was fair. There was some evidence that the plaintiff hadn't engaged in the off-label marketing. And there was evidence here that the plaintiff was treated in a manner that was a little bit inconsistent with the way the company investigated other situations. So it really made an easy roadmap for the jury to find, and find big in this case, even with a verdict in favor of the plaintiff. $2 million on a service letter claim is that jury saying, company, we're really upset at you, and we're going to show you here on that case.
So that's actually a good segue, because we're going to go to one where the employer wins. And the employer wins here because, in contrast to some of what Randy was just describing in the last case, in this particular instance, the employer acted very well. And I'm going to apologize in advance. The facts of this case are challenging to listen to, but they're not unusual for the types of cases that we handle in the employment world, particularly when you're involving or you're considering sexual harassment. This was a case filed by a minor against Six Flags. We're all familiar with Six Flags. It's an amusement park that operates in various parts of the country, including near St. Louis here on the eastern side of the state. The plaintiff, as I mentioned, was a minor. The alleged harasser was a minor. And 2 other minors were involved as well. It's not unusual to, in the summertime, have a lot of high school and college-aged students working at Six Flags, and that was the case here. So this all took place within the span of just a few days in July of 2016. The claims were, of course, that this individual, this minor female, was subjected to a hostile work environment. And as mentioned, it happened with a group of 4 minors together over 2 days. The first incident happened early in the shift, like I said, in July. The 4 of them, 2 boys, 2 girls, were in the same room together cleaning these 3D glasses that are used for a particular ride at the amusement park. While they were in there, one of or both of the boys said to the other girls, "Oh, there's 2 boys, 2 girls, we should get it on." The conversation continued from there. The boys pulled their pants down, not their underwear, but they did pull their pants down. Pretty quickly after that, the 2 minor females suggested to them that they're not interested, they don't want this to continue. The 2 boys grabbed one of the girls by the arm, pulling on her a bit. She pushed them away. It's not apparent from the lawsuit as to whether the pulling was to force any sort of sexual contact, but there was a touching. And it continued a bit. One of the boys, after they released her, stepped on her hair. This all happened in this room together with the four of them toward the end of one shift. After that incident ended, the plaintiff went and clocked out. She left Six Flags and was done for the evening. The other three employees decided to stay behind. This was called a ride night, where the employees got to stay and ride the rides for free. Apparently during that night, one of the boys and the other girl who remained behind continued to interact throughout the evening. And then we go fast forward a bit to the next day, the next shift. One of the boys who was in the room and who stayed around interacting with the other girl came up to the plaintiff and suggested, you shouldn't have left, you should have stayed. In fact, let me show you this video that he had of him and the other female employee from the night before, where she was performing oral sex on him. Pretty quickly after him starting to show it to the plaintiff, she smacked it away, saying, I don't want to see that, and reacted fairly strongly to having been shown that video. He pretty quickly sort of swung back at her. The language used in the case was that he karate chopped her in the head and told her that she better not tell anybody about this. Thankfully, that didn't work. She immediately went to HR and told them exactly what happened. HR acted immediately, removed the two boys from their shifts, suspended them pending the investigation, and they conducted the investigation immediately, talking to all of the four people as soon as they could. And when it came to the plaintiff, the female minor, they contacted her parents ahead of time because she was a minor to let them know that this investigation was going to be going on and they could be involved if they wanted to. Because of the information they uncovered, Six Flags immediately fired both boys roughly a day or two after learning of the complaint. And they offered to the plaintiff that if she were no longer comfortable working in this area because of the things that had gone on, they would move her somewhere else in the park. They even contacted the police because one of the boys who had been fired, again a minor, had a video of him engaged in a sexual act with another minor. So they acted quickly, decisively. They removed the individuals from the situation, and they did what we call under the law, took prompt and effective remedial action. And so the lessons to be learned here is that when you promptly investigate and you conduct a thorough investigation, you interview everyone who's involved, you make sure you're getting statements, written statements was another important part of the case. You give opportunities for all to be heard, and then you take prompt and decisive action that addresses the situation, that remediates the issue so that the harassment no longer continues. You as an employer can insulate yourself from liability even in the context of ugly action like this. When you're talking about coworker on coworker harassment, employer has the opportunity to take prompt and effective remedial action and absolve themselves of liability. The other important part of this, and this is the other tip that you see on your screen, is that both the victim and the harassers had gone through training during orientation about their sexual harassment reporting policies. And so when these things happened, thankfully, she knew what to do. She was able to act on it, and the company was allowed to take those steps. So you as an employer need to have a policy, need to train on it, and then make sure that your individuals who are charged with enforcing it know the right way to handle these issues, and then take the proper steps. Because they did all of these things, Six Flags never even had to go to trial. They were successful on what we call summary judgment, which is basically a briefing filed with the court saying that they took these steps, they did the right things, they complied with the law, and therefore won. And it's a wonderful lesson to all of our employers as to how to act in these particular situations. An unfortunate situation for the plaintiff to have to endure, but the right result and reaction from the employer. And I'm going to turn it over to Kate now, which is appropriate not only because she's the next speaker, but she was also local counsel on that Six Flags case.
Thanks, Joe. All right, so the last case we're going to briefly touch on is Wiseman versus Missouri Department of Corrections. So Lisa Wiseman was the plaintiff in this case. She was a 30-plus year employee with the Department of Corrections in Kansas City. Her most recent job was deputy warden. Throughout her very lengthy employment, she had a pretty good employment record when you looked at the documents. Her performance evaluations every year were pretty positive. She didn't have much discipline other than, you know, a couple of minor things here and there. In 2016, she testified as a witness in a discrimination case. The day after she testified, her testimony was discussed during a board of directors meeting with the Missouri Department of Corrections. A week after that, she was placed on a performance improvement plan, her first performance improvement plan, and it was for, you know, unprofessional behavior that she was engaged in with other staff. Fast forward to 2018, she testified as a witness in another discrimination case, and very shortly after that, her employment was terminated for, again, unprofessional conduct with staff. I think the last comment she made, which it wasn't this in and of itself, but one of many things that led her employer to terminate her employment was she said she didn't fall off the turnip truck yesterday. So she just had some conflict with how she communicated with her coworkers. Well, in this case, she was awarded over $11 million. The jury found that the timing of this looked very, very suspicious. You know, placed on a performance improvement plan a week after testifying in the first discrimination case, and then her employment was terminated very shortly after testifying in the second discrimination case. And again, you know, you have to think of how the documents look. And this was a 30-year employee for decades, had, you know, relatively positive performance reviews. And then as soon as these two events happened where she was giving testimony that was unfavorable, you know, for her employer, suddenly she's on her way out and then is ultimately separated from the company. So, I mean, of course, lessons learned, do not retaliate. But, you know, even if, you know, most employers know that that is illegal to retaliate against someone for that type of testimony. But you have to keep in mind how the document trail is going to look and how it's going to look to a jury. I mean, in this case, they actually had an opportunity to settle the case for, and this is part of the public record, for $2 million, but they, the employer turned that down and then got hit with an $11 million verdict. So, you know, lessons learned, you know, it's human nature to not want to say negative things in people's performance reviews and just say, yep, they're doing a good job. But, you know, if there are performance issues, those need to be documented as they're happening. Number one, most importantly, so that the employee has opportunities to improve. But, you know, in a case like this, when the employer said, no, you know, these were issues with her, you know, dealing unprofessionally with staff that have been happening for, you know, years and years. But if it's not showing up in the documents, it's going to look very suspect. So, you know, as hard as it may be, just lessons learned, you know, document employees' performance accurately, even if that means saying negative things. Again, it will help them improve, but it will also be helpful for defenses in cases like this, where, you know, an employer may want to terminate someone, and obviously not directly in retaliation for a protected activity, but if, you know, the timing looks suspect, having the evidence to back that up on the front end will be very helpful. So that's all we've got for this section. I will kick it back to Paul in Kansas City to wrap up our seminar for today.
Thank you, Kate. Thank you all for the presentation, and thanks to all of the attorneys who presented today, particularly those who had to scramble, get to other rooms, get to other microphones, things like that, as we tried to deal with our audio issues. So I'm sure you all can imagine it was kind of an anxious time on this end as we did that. So I thank the folks who were so flexible on that. But most of all, thanks to you all, again, our audience, for staying with us. Hope there was some good content that you enjoyed. Most of all, thank you very much for your patience through this. Obviously, we were very well aware that there are audio issues. We thought we had them corrected. They raised their head a little bit more later. What we're going to do, we're going to take a look at it. It should be, if things are working right, the recording that you have ought to have the audio appropriately done and with closed captioning as well. But we're going to check that and figure it out. If we don't, then we're going to look at options for re-recording some of the portions that where the audio was poor. So again, we apologize that, and thank you very much for your patience. I would be remiss if I didn't recognize the support staff who helped us out on this. If you've ever had the pleasure of trying to herd attorneys to turn in their PowerPoints on time and then to revise them at the last minute, you'll know what I'm talking about. Also, our AV folks who walked us through, you know, the red light means the camera's hot and the green light means it's not. And then to have the attorneys argue that that's counterintuitive and it really ought to be the other way. Again, you know what I'm talking about. And finally, obviously, the scrambling that they did during the audio portions, the problems to get us to other rooms, to get us with other microphones, things like that, truly did a wonderful job. So in Kansas City, I really want to recognize Emily Schumacher, Shana Hoy, Jeff DuCoin, Brian Kane, Donovan McGoldrick, and Jamie Powell. And on the St. Louis side, Andrea Reed, Erwin Matthews, and Tim Chesler. Thank you very much. We truly appreciate it, and we absolutely couldn't do it without you. Reminders, down at the bottom of the screen, the CEU icon, you can record to get your CLE or HR credit there. You'll also receive a survey that allows you to give some constructive feedback on this. Feel free, let us have it about the audio. I mean, we deserve it. We need to hear it. And thanks for the comments along the way, letting us know when there were problems as well. But let us know that. Also, let us know about any other topics you'd like to hear about. We truly look at that first thing when we're setting up the agendas on these things. Also, let us know if now that we're hopefully kind of out of COVID, if you're looking forward to getting back in person for some of these seminars, or if it's just become so convenient, audio problems notwithstanding, to have the virtual seminars as well. We really want to hear about that. If you want to be in person, we'll be looking at that. I also invite you to let your contact at Husch Blackwell know if you want to be on any e-blast lists that you aren't currently on our blogs, have access to our blogs. Anything you need, I invite you to follow up with your contact. This concludes our program. We thank you for joining us. Overall, we thank you again for your patience, and we invite you to enjoy the rest of your day. Thank you.